Okay, let's dive right into this explainer. We're looking at a completely disastrous 1856 flood that literally revolutionized how the law views accidents and blame. I mean, if you've ever wondered how judges actually decide who's at fault when things go completely sideways, the answer traces all the way back to Victorian England. Today, we are breaking down the absolute landmark case of Blyth v. Birmingham Waterworks Company. It's essentially the legal battle that wrote the modern rulebook on negligence. So, picture this. Imagine your house is suddenly flooded. The water's rising, all your stuff is ruined, and you are left facing an absolute nightmare of a cleanup. Naturally, your instinct kicks in, right? You want someone to pay for it. But as we'll see as we unpack this, the law asks a much trickier question about who's actually at fault. It asks us to kind of separate our completely valid emotional desire for compensation from the cold, hard logic of legal liability. Basically, does a terrible outcome automatically mean somebody did something legally wrong? Part 1. A disastrous winter flood. Our story starts with Mr. Blyth, who was just an ordinary homeowner, and a super important number, 25. So the Birmingham Waterworks Company was in charge of the city's water supply. They installed this underground fire plug near Mr. Blyth's home, perfectly following all the rules of the time. And here's the kicker. For 25 years, that plug functioned absolutely flawlessly. I mean, for 2.5 decades, it did exactly what it was supposed to do. No leaks, no issues. It was a perfectly maintained piece of infrastructure. But then, nature threw an absolutely massive curveball. One of the most severe frosts ever recorded in the city's history struck Birmingham. Temperatures plummeted to completely unheard of depths. And this extreme cold seeped deep into the ground, freezing the water inside that perfectly functioning fire plug. Now, as we know from basic science, water expands when it freezes, right? The pressure built up, the plug burst, and a massive amount of water dumped straight into the surrounding ground, completely flooding Mr. Blythe's house. Part 2. The legal showdown. Looking at his completely ruined property, Mr. Blyth naturally sued. And the court found itself having to weigh two completely opposite arguments. On one side, Mr. Blyth is saying, hey, a reasonable water supplier should have prevented this. Your failure to do so is pure negligence. But on the flip side, the Waterworks Company argues they were perfectly careful. I mean, the plug worked for over 20 years without a single defect. They argued this was a freak, extraordinarily severe frost that literally no one could have anticipated. So think about it. If you're sitting in the judge's chair, who do you side with? The homeowner with the ruined house, or the company whose equipment worked perfectly until a totally freak act of nature? Part 3. The verdict and reasoning. So the judges in the Court of Exchequer had to establish a real framework for accidents here. And, surprisingly to some, especially if you're sympathizing with the homeowner, the court actually ruled in favor of the water company. They decided the Birmingham Waterworks Company was not legally liable for the damage. The court essentially said that just because a terrible accident happened, and just because Mr. Blyth suffered a real loss, it doesn't automatically mean the company was negligent. Baron Alderson was the judge who delivered this legendary ruling, and he gave us this exact quote. He said, "Negligence is the omission to do something which a reasonable man would do, or doing something which a prudent and reasonable man would not do." Actually, scratch that. Let's put it in everyday terms. He's basically saying that an accident alone doesn't prove negligence. To be liable, you have to have actually failed to act the way a normal, careful person would have acted in that specific situation. Part 4. The reasonable person standard. This one ruling birthed what we now call the reasonable person standard. It is absolutely the core legal concept used to judge accidents in courtrooms everywhere today. And it's a great reminder that the law doesn't demand absolute, flawless perfection from us. It just demands reasonable care. Whether you're driving your car or maintaining a city water pipe, the law measures your actions against an imaginary, ordinary, prudent person. Did you take the basic, logical precautions a normal person would? If yes, and an accident still happens, you aren't legally negligent. The water company had maintained their pipes to a perfectly normal standard for 25 years. And that brings us to another huge concept cemented here: foreseeability. Look, the law doesn't expect you to have a crystal ball. You aren't required to guard against completely extraordinary freak occurrences. Because that 1856 frost was such an exceptional, unforeseeable event, the water company couldn't have possibly anticipated it. And if you can't foresee a risk, you can't take precautions against it, which means you aren't negligent. Part 5. The enduring legal legacy. It's honestly amazing how a dispute over a flooded Victorian home laid the absolute foundation for how we handle personal injury and property damage claims today. Let's recap why this is so huge. First, it established the classical definition of negligence that law students still memorize on day one. It introduced the reasonable person test as our ultimate legal measuring stick. It decisively clarified that an accident on its own does not prove negligence. It highlighted how absolutely crucial foreseeability is. And its legacy is so remarkably strong that courts all over the world, from the US to India, still cite it today whenever negligence is on the table. So, as we wrap up this explainer, I want to leave you with a thought. The next time something goes wrong, whether you spill your coffee or see a fender bender, ask yourself, would a reasonable person have seen it coming? Were the actions taken perfectly ordinary or genuinely careless? Because thanks to Mr. Blyth and a very, very cold winter in 1856, that is exactly the question the law is going to ask.